ends and jeopardize rights of innocent people like me, jeopardize rights of innocent people, so as to wreak vengeance for their personal ends. This has become very handy to the developers in matters of public contracts. In order to serve professional rivalry, they utilize services of innocent people, etc., etc. Then, my lord, after referring to Balco, this is what they say, your lordship say in para 26, we fully share the view expressed in the aforesaid decision of this court and reiterate that it should go as a warning to the courts that this extraordinary power should be used sparingly and absolutely necessary matters involving downtrodden people. Involving downtrodden people. There is nothing noted. In this connection, learned counsel has rightly pointed out delay is material. He has invited our attention to number of decisions of this court where this court has declined to interfere on account of delay. Para 27 onwards, then your lordships of the Supreme Court refer to various judgments. Para 34, there is no doubt that a delay is a very important factor while exercising extraordinary jurisdiction under 226. We cannot disturb third-party interest created on account of delay. Even otherwise also, why should court come to the rescue of a person who is not vigilant of his rights? Now, my lord, I have received a money. Should I return it? What is this kind of a case? I don't understand, my lord. 2004, we are in 2024. He moves the courts and says this sale was bad. I had no right, title, and interest. Who is he to question, my lord? The buyer could have questioned, authorities could have questioned, not a PIL petitioner on false documents. So, my lord, that is why it is very important that your lordship should not entertain this kind of a petition. So, my lord, that's so far as the delay is concerned.
Now,
On
reference to CBI.
Yes, my lord. No, my lord, on estoppel and acquiescence, I want to cite one judgment. My lord, that's little crucial.
Citation?
Well, I'll just give me a minute, my lord. I'll just give you a lordship.
What is this? Huh? Is this the way? Should we not have a list and give it to the other side beforehand when senior is submitting? Work of advocate on record. What is this?
My lord, it's entirely my fault. I must take the risk on my shoulders.
But it is these.
Sorry, I didn't share it with anyone. My lord, I have not shared it. So that's why I'm saying,
their goods. Yes.
Would your lordships keep it post lunch? I will give the list and lord so that we can argue.
No problem. You read it, sir. No problem. You can give it later post lunch even to Maninder Singh sir also.
Lord, I have a bad habit of even surprising my briefing counsel.
The innocent omissions of giving it to us, my lord.
Yes.
Earlier also. In similar matter, earlier also we don't get it. We only get it after their case.
Correct, my lord. I agree. I have a habit. I agree, my lord. To Mr. Maninder Singh. I agree, my lord. To Mr. Maninder Singh.
Yes, sir. Next, acquiescence.
2022. Yeah. Lord, 2022, Volume 2 Supreme Court Cases, page 25. Union of India versus Murugesan. Lord Justice Sundaresh speaking for the court, sitting with Justice Kaul. And Lord, is a very, very beautiful discussion on delay, laches, and acquiescence, starting from para 20. Your lordships may just note. And the court says that there is relationship between acquiescence on one hand and delay and laches on the other. Then, my lord, para 26, approbate and reprobate.
Yes.
These phrases are borrowed from Scots law. They would only mean that no party can be allowed to accept and reject the same thing. And thus, one cannot blow hot and cold. This principle behind the doctrine of election is inbuilt in the concept of approbate and reprobate. Once again, it is a principle of equity coming under contours of common law. Therefore, he who knows that if he objects to an instrument, he will not get the benefit he wants, cannot be allowed to do so while enjoying the fruits. So he's enjoying the fruits of an investigation ordered by Lokayukt court. Now he comes and says, transfer it to CBI. One cannot take advantage of one part while rejecting the rest. A person cannot be allowed to have benefit of an instrument while questioning the same. Such a party either has to affirm or disaffirm the transaction. This principle has to be applied with more vigor as common law principle if such a party actually enjoys one part fully and on near completion of said enjoyment, thereafter questions the other part. Now, my lord, he is trying to today stifle the investigation. His aim is somehow convict all these people. Supposing, my lord, local police independently comes to a conclusion that there is no case made out, which I have shown from my counter affidavit, then he will say, oh, local police is influenced. It is now giving a clean sheet, and therefore your lordship should refer it to CBI. No, my lord, that your lordships will not permit. That's unfair. That's unfair, and it seriously impairs my right under Article 21 and Article 14. Then, my lord, it is said, an element of fair play is inbuilt in this principle. It is also a species of estoppel dealing with conduct of a party. We may have dealt with the provisions of so and so. Then, my lord, lordships refer to various judgments of the Supreme Court and, my lord, deal with 226 and, my lord, these principles. We would not delve deep into extraordinary and discretionary nature of relief. This principle has to be extended much more when an element of undue delay, laches, and acquiescence is involved. Para 28. This principle is much more important in 226. Supreme Court says. Para 28. And then they refer to various judgments, including UP Jal Nigam, Dhan Gupta, Eastern Coalfields, and many other judgments. Almost 15 judgments are. It's a very beautifully discussed judgment, and I commend it to your lordships for acceptance of this and follow this law.
Next, sir.
High Court had interfered in this case. So in
Yes.
para 40, this is
That
what your
is-
lordship say. We find much water has flown under the bridge. Private respondent has already been appointed in 2016 after following due procedure and continues to date. Respondent is an ex-employee of First Appellant Society and having put in 23 years of service knows its functioning very well. Thus, in our considered view, order passed by division bench cannot be sustained in the eye of law. So, my lord, your lordship set aside that order of the.
No, that's on the principle that you can't unscramble the scrambled egg.
Yes, my lord, that's the principle. I am so grateful to your lordships. Now, my lord, on the aspect of CBI, my lord, reference, my lord, kindly turn to my lord Constitution Bench judgment 2010, 3 Supreme Court cases,
State
571.
of West Bengal.
Yes, my lord. And my lord, what is important, I'll just read, my lord, one or two paras. See, this power is to be exercised when, my lord, somebody's life is taken away.
Para 70.
Yes, my lord. Of transferring it to CBI. It's not that, my lord, in this kind of, my lord, alleged corruption where there is none, or, my lord, private contracts and all kinds of nonsense. My lord, everybody moves.
I think para 70, correct?
First para 56.
56 and 70.
57, 56, 57, my lord. Then, my lord, I will come to, my lord, one para, my lord, para 64, my lord. Lord, after referring to Gopalan and Maneka Gandhi, your lordship say that it is Article 21's violation which gives you power to intervene. It's violation of Article 21 which gives your lordship a power under Article 21, para 64.
Yes, sir.
Then conclusions, my lord, para 68.
Yes.
And this is very important. Conclusion 68, Roman 2. Article 21 of the Constitution in its broadest perspective seeks to protect persons of their lives and personal liberties except according to procedure established by law. Said article in its broad application not only takes within its fold enforcement of rights of an accused, but also rights of the victim. State has a duty to enforce human rights of a citizen, providing for fair and impartial investigation against any person accused of commission of a cognizable offense, which may include its own officers. In certain situations, even a witness to crime may seek for and shall be granted protection by state. So, my lord, it's in the context of 21, not, my lord, these ordinary cases of corruption. Then Roman 3, in view of the constitutional scheme and jurisdiction conferred on this court under 32 and 226, the power of judicial review being an integral part of basic structure of constitution, so and so. Then, my lord, para Roman 6, in terms of entry 2 of list 2 of 7th schedule on one hand, 2A of list entry 80 of list 1, investigation by another agency is permissible, subject to grant of consent by state. There is no reason why. In an exceptional situation, the court would be precluded from exercising same power which union could exercise in terms of state provision. Exceptional situation. But in my respectful submission, this is not an exceptional situation. The petitioner and the petition do not make out a case of exceptional situation. There is no such case except bald everments that he is chief minister, therefore police is under him. But he was chief minister when you went to Lokayukt court and made a complaint. And you had faith in Lokayukt court. You can't suddenly blow hot and blow cold. Then, my lord, para 69. Para 69, last 3 lines are very crucial. Being the protectors